Okay.
Okay. And so then I will make a record that I've read that competency evaluation and I have no objection to the finding from the second evaluator saying that you are competent to proceed. And then the competency proceedings will conclude at that point. The judge will ask what we want to do with the case. You still have the right to have a preliminary hearing. If you wanted to fire me, that's fine. You have the right to proceed what's called pro se, which means on your own. And then the judge would probably ask to get you documentation to review with regard to your rights or go over those rights with you so that you would be able to proceed pro se, and then you'd have to get communication between the district attorney and yourself with regard to collecting discovery for yourself. Do you understand that?
Yes, I do.
Okay. The other issue is if you're saying that you want to just fire me, but you want a different attorney, with the public defender's office, you're not allowed to pick which attorney that you are assigned. And so if you're saying that there is some sort of breakdown in communication, or that you don't want my services, but you do want a different attorney, that's different than saying that you want to just proceed pro se or on your own. Does that make sense?
Yes, it does.
Okay. And so if that's the route that you want to go, then the judge would and you could tell this to the judge. I'm certainly not trying to tell you what to say, but I could also explain it to the judge. What it is called is a burger root hearing, okay, and that's where the client informs the court that he or she believes that there is a conflict between the client and the attorney, and then we have to ask for a separate judge to hear the conflict or what that conflict is, and then that separate judge makes a determination about whether or not there is or is not a conflict. And if there is not, then I remain your assigned attorney. If there is, then the judge, the other separate judge, makes that finding and then informs Judge Engelhoff, who we are appearing in front of, that there is a conflict, that you're still entitled to an attorney, but that alternate defense counsel needs to be appointed. Does that make sense?
Yes, it does.
Okay. So and that's why I wanted to talk to you about this before just calling your case, because I want you to understand what your options are. Understanding what your options are, do you have a decision about whether or not you would like to proceed on your own pro se, or if you would like to indicate to the court that there's a conflict and request that burglary hearing?
I have a few questions first. When it comes to the preliminary hearing, prior to the competency evaluation stuff, you kept informing myself and the court that there was no evidence. Is that still going on? Do we still not have the halo cameras and body cameras issued from the police?
Correct. So I did inquire about the existence of halo cameras and body-worn cameras, and the police officers are claiming that none exist.
But at first they said there were.
Right, and I understand that there are issues with that, and those are evidentiary issues that could be raised all the way through the trial, including at the preliminary hearing, a motion to suppress the stop and any alleged statements, and at trial later on down the road. Absolutely. Right now, my understanding from talking and from exchanging emails with the district attorney is that there is no body-worn camera available.
So I remember I once asked you about a motion for dismissal of charges due to lack of evidence.
And so at a preliminary hearing, there can be an argument made that the case should be dismissed for lack of probable cause. Probable cause is a very low standard. It does not require that the district attorney present video evidence. There can be testimony from police officers claiming, as you and I can both anticipate that they would claim, just like the police reports are saying, that they're claiming that you ran in the car and attacked the officer and tried to steal the car, all that business. And so they would come to court, testify in that manner, and then the judge would be asked to determine whether or not there is probable cause to proceed forward on those charges. Okay?
Okay, I would like to proceed pro se at this moment.
Okay, I understand. had an opportunity to discuss your case, that you would like to proceed pro se. The judge is going to ask you questions about understanding what that means, and then you'll probably have to exchange contact information, either a phone number for the DA's office or an email for the DA's office to collect discovery in your matter, okay?
Okay. And I've gone pro se before, and as going pro se, a prior judge required that I have an assistant who is a lawyer.
Okay.
Will
Called
that?
advisory counsel. You
Yes.
can certainly ask for advisory counsel. I don't know what Judge Engelhoff's practice is in appointing advisory counsel or not. The other judges in Denver District Court that I have appeared in front of have indicated that they will not do that. But I don't know what Judge Engelhoff's practice is.
Thank you very much.
Okay, so I'll get you called up as soon as I can. Okay, sir?
Thank you, sir.
Uh-huh.
Bye.